Whenever I think about the intelligence failures that surrounded the 9/11 terrorist attacks, I always think of the old proverb, "For want of a nail." You're no doubt familiar with it. For want of a nail, the shoe was lost. For want of a shoe, the horse was lost. For want of a horse, the rider was lost. For want of a rider, the message was lost. For want of a message, the battle was lost. And for want of a battle, the kingdom was lost. And all for the want of a horseshoe nail. It describes what we also know as the butterfly effect, how the failure to account for one seemingly small detail can lead in the end to some extraordinary result. In some ways, we might think of the story of 9/11 as such a parable about the want of a preposition. Who would have thought that the tragedy of 9/11 could be tied to a preposition? That is, the difference between the and a. Or if you want to be a little more specific, the distinction between the purpose and a significant purpose. I trust that introduction is sufficiently mysterious. But it does help to frame and capture the issues that arose from FISA, that is, the Foreign Intelligence Surveillance Act, and how, in some ways, the issues that arose from it contributed to our failures in September 2001. And by the end of this lecture, I hope you'll understand why. Here's a short summary of the issue. In October 1978, President Jimmy Carter signed into law FISA legislation that established a new framework for American policy, mandating a strict separation not of church and state, but of the CIA and the FBI, or more broadly, between criminal law and espionage. In effect, the Congress erected a wall between intelligence gathering and law enforcement after the Senate Church Committee uncovered Cold War-era abuses in U.S. intelligence agency practices. The new law was a procedural mechanism to restrain the surveillance state. Did this wall imperil, rather than protect American democracy, come September 2001? Some think so, though others have their doubts. Let's begin this story through the experience of one female FBI agent named Colleen Rowley, who might have been able to connect the dots before 9/11 if not for statutory limitations that kept the FBI from pursuing an important lead. In August 2001, Agent Rowley was newly assigned to the FBI field office in Minneapolis, Minnesota. That same month, FBI agents got a tip that an individual, someone we now know to have been Zacarias Moussaoui, was taking flight training in an unusual manner. Apparently, or so the report goes, Moussaoui was intent on learning how to take a plane off the ground and fly it in the air, but uninterested in learning how to land the plane. You will, of course, naturally understand why this is unusual, since landing a plane is the most difficult part of the task at hand, and typically also something that every pilot thinks is essential to master. The FBI, during its investigation of this odd tip, determined that Moussaoui, a French citizen, had overstayed his right to remain in the United States. He had been admitted for 90 days under the so-called visa waiver program that the U.S. extends to 29 countries, including France, but remained here after that time limit had passed. Responding to a follow-up inquiry from the FBI, a U.S. officer of Immigration and Naturalization Services reported that Moussaoui's overstay subjected him to arrest. And so, the FBI took him into custody in an attempt to discern his intentions. After Moussaoui was arrested, the FBI's Joint Terrorism Task Force began conducting a more comprehensive investigation. They learned from French intelligence sources that Moussaoui was affiliated with radical fundamentalist Islamic groups, including one connected to Osama bin Laden. The agents, therefore, wanted to search Moussaoui's personal effects and the contents of his laptop computer. When Moussaoui refused to consent to the computer search, agents' suspicions were aroused. Based on the information they'd already gathered, plus the information from French intelligence, the FBI agents thought they had probable cause to believe that Moussaoui was engaged in criminal activity, and thus that they had the basis for a criminal search warrant. However, because part of their probable cause suspicions were based on intelligence collected by the French, they needed approval from a headquarters unit at the Department of Justice known as the Office of Intelligence Policy and Review, or OIPR, to apply for the search warrant. That approval would also have been required if the intelligence had been collected by the CIA. The Office of Intelligence Policy and Review was created in the wake of the FISA law to monitor and restrict the transfer of information from the intelligence community to law enforcement. These restrictions colloquially came to be known as the Wall. Because of concerns that U.S. use of French intelligence information might be inappropriate in a domestic matter, FBI higher-ups in Washington opted not to ask the Justice Department's Office of Intelligence Policy and Review to authorize the application for a criminal search warrant. FBI headquarters also refused to authorize an application for a warrant to the Foreign Intelligence Surveillance Court, or FISC, the court set up by FISA to review the applications filed by the government. Apparently, the grounds for this decision were the belief that the FBI had not yet gathered enough information to connect Moussaoui to an unfriendly foreign power or movement, and the FISC was only authorized to issue a warrant when the evidence made that type of connection. And so, Justice Department lawyers made no warrant application to the Intelligence Court, and nothing was done with the Moussaoui information. Sadly, this failure to connect the dots was compounded by other failures in the FBI's review process. What FBI headquarters in Washington knew, but the field office in Minneapolis did not, is that just 3 weeks before Moussaoui's arrest, the FBI field office in Phoenix had forwarded information to headquarters with the tip that al-Qaeda operatives would be attending flight schools seeking flight training for terrorist purposes. This July 2001 memorandum to FBI headquarters was written by Phoenix Special Agent Kenneth J. Williams. The memo warned of possible efforts by Osama bin Laden to send students to the United States to attend civil aviation universities and colleges. After the successful attacks on the Pentagon and the World Trade Center on September 11, 2001, the very same information that had earlier been deemed insufficient for a search warrant was used as a basis for authorizing the search of Moussaoui's computer. Of course, the only thing that had changed in the interim was the horrific attack. As Colleen Rowley put it in a letter to FBI Director Robert Mueller, complaining about the obstacles the agency had encountered in attempting to do its job, quote, "To say that probable cause did not exist until after the disastrous events occurred is really to acknowledge that the missing piece of probable cause was only the FBI headquarters' failure to appreciate that such an event could occur." We will never know what might have happened if Rowley's request had been approved prior to 9/11. Perhaps nothing, or perhaps everything. So with Rowley's experience in mind, let's back up a bit and try to understand exactly what this wall was, why it existed, and what effects it had on U.S. counterterrorism activity. As we will see, the best answer seems to be that the wall was erected at a particular moment in time when terrorist threats seemed to be receding and when government threats to civil liberties seemed to be increasing. The wall stems from an era when legal, social, and bureaucratic restraints on communications between the intelligence sector and law enforcement were thought to be an important limit on governmental intrusion. FISA legislation, in the years before the terrorist attacks, but after Congress uncovered a string of errors and abuses in the intelligence sector that encroached on citizens' rights, strengthened the barrier between intelligence and law enforcement communications to abate such errors and excesses. So the first question we might ask is, why does the wall matter at all? Or, flipping it around, why is there value in separating law enforcement methods from intelligence activities? The answer lies in the different procedures and forms of inquiry they use. There's a clear distinction between criminal investigations, which are typically conducted under Title III of the Omnibus Crime Control and Safe Streets Act of 1968, known as Title III investigations, and national security investigations, which are conducted under FISA. The latter, relating to national security, provides considerably more deference to the executive branch at every step along the way. For instance, while Title III and FISA alike require government officials to obtain ex ante permission from judicial officers for electronic surveillance, courts under Title III, that is, criminal law enforcement, impose a far stricter standard of review before granting authorization. Furthermore, after the surveillance is complete, aggrieved parties under Title III who say that the government has made an error have substantial rights to challenge the government's conduct. Those rights are virtually non-existent in the FISA regime. Under Title III, the fruits of electronic surveillance can be used in a prosecution only if the defendant is first given copies of the government's application and the court order approving the surveillance. FISA applications, on the other hand, are generally not disclosed unless ordered by the court, which is limited as to when it can order disclosure. As a practical matter, defendants in criminal actions rarely have access to FISA applications. Even evidence relating to defendants under investigation for simple domestic crimes, like, say, drug smuggling, may sometimes be discovered as a collateral part of an intelligence investigation. When that happens, however, the accused drug dealers will usually not see why it is that the government got the authorization to conduct surveillance in the first instance. The application remains cloaked in FISA's secrecy blanket. Perhaps now you can see the difficulty. An earlier Supreme Court decision in the Keith case, which pitted security concerns against civil liberties during the administration of President Richard Nixon, found that domestic surveillance, whether for criminal or national security reasons, had to fully satisfy the warrant requirements of the Fourth Amendment. The Fourth Amendment, of course, prohibits unreasonable searches and seizures and requires any warrant to be judicially sanctioned and supported by probable cause. But implicit in this requirement for domestic surveillance is the idea that surveillance of a foreign national for national security purposes might be subject to a less stringent reasonableness standard. Courts around the country soon agreed, holding that surveillance for foreign intelligence purposes needed to be reasonable, but might not require a warrant. How do you make such a distinction between domestic criminal and foreign intelligence activity? Information, after all, doesn't come with a sign on it that says, "Use me only for foreign intelligence purposes." And once you collect information, it becomes hard to deliberately forget it. What if, say, during the course of surveilling a Russian spy, the CIA discovers information about a Russian drug ring? Does it close its eyes to that? Or does it share with the FBI? You can see the problem. To answer, the courts have developed something that has come to be known as the primary purpose test. It started with the Vietnam War-era espionage case titled United States versus Truong Dinh Hung. Here's a description of the case, derived from a paper by Scott Glick. Truong was a Vietnamese citizen and the son of a prominent Vietnamese politician. As part of an effort to disrupt the peace negotiations, he asked a Vietnamese-American woman named Dung Krau to carry packages for him from the United States to the Vietnamese community in Paris, where peace negotiations were taking place between Vietnam and the United States. The packages contained copies of diplomatic cables and other classified papers of the U.S. government. As Glick, a national security lawyer, describes it in an article for the Harvard National Security Journal, the FBI targeted Truong's telephone and apartment with electronic and audio surveillance. Commenced as a spying investigation, no court authorization was obtained. In the end, Truong was arrested. He was charged with conspiracy and espionage. All of the evidence that was collected from him during the electronic surveillance was turned over to him as part of the discovery process, where criminal defendants get to see the evidence that the government has collected and intends to use in the prosecution. Truong's defense counsel argued that the evidence had to be thrown out. His reasoning was that the government's investigation of Truong was actually a criminal one and not an intelligence matter. If it had been criminal, then it would have required a court order in order to conduct the surveillance. The court took testimony in the matter, including from then Attorney General Griffin Bell. It decided that while the investigation might have begun as a foreign spying investigation, at a certain point, the investigation became primarily criminal. For that reason, the court said that a warrant was required to conduct the surveillance, and that without the warrant, the Fourth Amendment had been violated and the evidence would be tossed out. A few years earlier, when the FISA was enacted, the Congress tried to preserve this distinction by stating that the more relaxed FISA procedures, for which a criminal warrant was not required, applied only when the purpose was to collect foreign intelligence. Note, by the way, that the law does not say the primary purpose, but that has generally been read into the language. So now, the lawfulness of this surveillance would be determined by the intent or purpose of the investigation. If it were for foreign intelligence, then FISA procedures apply. If for anything else, the government had to apply the more stringent Title III rules. How do you measure intent, though? Since we can't read people's minds, we judge intent by their actions. If I hit you with my fist in your face, then I probably intended to hit you. After Truong, some Justice Department officials used the same logic to prohibit consultations and coordination among law enforcement and intelligence agents and prosecutors. They were afraid that federal courts that might look at coordination between law enforcement and the intelligence community and think that they were impermissibly using the relaxed FISA rules to collect evidence for a criminal case. The more such consultations occurred, or the more FISA was used to obtain evidence for a criminal prosecution, the more likely courts were to find an improper purpose, they believed. So they decided that we needed rules limiting consultation, sort of a preemptive strike against being accused of an improper purpose. In July 1995, President Bill Clinton's Attorney General, Janet Reno, approved coordination procedures that applied in most cases. As Glick says, quote, "The guideline limited contacts between the FBI and the Justice Department's criminal division in cases where FISA collection was taking place, in order to avoid running afoul of the primary purpose test used by some courts." On their face, these procedures were stringent. They were meant to limit, but not prohibit, the coordination of intelligence and law enforcement activity. In practice, they seem to have been interpreted, some say misinterpreted, as a straitjacket. And so there you have it. As Glick, the prominent national security lawyer, rightly summarizes, the foundations of the FISA wall lie in the primary purpose test. DOJ acted as a barrier so that it could tell the courts that a wall existed. In other words, the wall was a procedural barrier that made it impossible to use intelligence for law enforcement purposes and therefore allowed OIPER to reassure the courts that intelligence collection was exclusively for intelligence purposes. One critical procedural aspect of the rules, the one that bedeviled the FBI Special Agent Colleen Rowley, was the requirement that specialized requests for surveillance had to go through FBI headquarters and the Office of Intelligence Policy Review at Main Justice. OIPR was both the wall and a gatekeeper, making sure that the FBI just didn't talk to the CIA, and vice versa. Why? What could account for this attitude? Some, of course, can rail against ignorance or malfeasance, but the likely answer is more prosaic. The creation of the wall and rules about it erected a compliance culture within the FBI and DOJ, where failure to follow procedure could result in adverse personnel actions. The congressionally authorized 9/11 Commission reviewed the function of the wall prior to the terrorist attacks and painted a depressing picture of bureaucratic rigidity. Over time, the Commission report concludes, the Office of Intelligence Policy Review and the Foreign Intelligence Surveillance Court itself, quote, began to see mere contacts between the FBI and the Criminal Division as a proxy for improper direction and control. Significantly, OIPR viewed its role primarily as an officer of the FISA court and therefore responsible for the stewardship of the court's responsibilities. It viewed its role as an advocate for its institutional clients, that is, the FBI, as secondary. In November 2000, the FISA court added a requirement that no one in the FBI or the Department of Justice, including persons working solely on intelligence investigations, could see FISA material before signing a form acknowledging that they understood the restrictions on sharing any information they obtained. One FBI supervisory agent referred to this form as a contempt letter. It assured that information sharing would essentially come to a halt because agents feared they would lose their jobs if they shared any intelligence information with criminal investigators. Although this wall of restriction formally applied only to FBI intelligence collection, it also came to be adopted by other intelligence agencies, again out of an overabundance of caution. Here's part of what the 9/11 Commission said about that phenomenon. Quote, the National Security Agency, NSA, also placed restrictions on the sharing and use of information it collected. Initially, these restrictions merely governed the use of its reporting in criminal matters. In December 1999, however, the NSA began placing new, more restrictive caveats on its bin Laden-related reporting. These caveats precluded sharing the information contained in these NSA reports with criminal prosecutors or investigators without obtaining OIPR's permission. A caveat, by the way, is just what its name implies, a limitation or a restriction on how information may be shared and with whom. An example is the caveat no foreign, which means that the information may not be shared with foreigners. One point often lost in the story is that the NSA couldn't always tell exactly what source it had gotten information from, a restricted FISA source or an unrestricted non-FISA source. Because of this, in the run-up to 9/11, the agency concluded, quote, that there was no administratively easy method to determine which of its reports were from FISA-based collections, according to the 9/11 Commission. Thus, caveats were added to all NSA counterterrorism reporting that precluded sharing the contents of the reports with criminal investigators or prosecutors without first obtaining permission from NSA's General Counsel. Consider, for example, what happened to the agency's surveillance of two of the 9/11 bombers. As the 9/11 Commission tells us, in December 1999, the NSA picked up the movements of Khalid al-Mihdhar, an individual then identified as Nawaf Mihdhar, which linked him to a terrorist facility in the Middle East. Mihdhar was tracked to Kuala Lumpur, where he met with other then unidentified individuals. Some photographs were taken of these men on the streets of Kuala Lumpur. The surveillance trailed off when three of them moved on to Bangkok on January 8, 2000. Those pictures became relevant to the FBI's pre-attack criminal investigation in July 2001. Unfortunately, as the 9/11 Commission found, the NSA reports contained caveats that their contents could not be shared with criminal investigators without the Office of Intelligence Policy Review's permission. Therefore, an FBI intelligence analyst who reviewed the material concluded she could not pass the information contained in these reports to the FBI criminal agents. She did not ask OIPR for permission to share the reports, nor did she explain to the agents anything about the caveats, only that she could not share the information due to the wall. Perhaps if she had asked for permission, it would have been granted. Perhaps not. Again, we'll never know. FBI Special Agent Colleen Rowley concluded, "I believe the chilling effect upon all levels of FBI agents assigned to intelligence matters and their manager hampered us from aggressive investigation of terrorists. Since one generally only runs the risk of Intelligence Oversight Board violations when one does something," she said, "the safer course is to do nothing." In short, the rules at issue probably weren't the problem. The problem was the culture of caution and the bureaucratic structures and infighting that arose to prevent the commingling of intelligence and law enforcement activities. In other words, the failures of 9/11 were less about statutory language and more about human fears, hesitations, an abundance of caution, and the inability of bureaucratic organizations to adapt to discrete circumstances. Even more than a wall, the law created a space, a dangerous void between the government's criminal and intelligence sides of the house. The reaction after 9/11 was swift. Rightly or wrongly, legislators blamed the wall for some portion of the failure that day. And because they can't change a culture, but they can change the law, it's the text of FISA that they focused on. In late September 2001, the executive branch sent Congress draft legislation proposing changes to FISA's certification requirement for electronic surveillance and physical search applications. In the area of foreign intelligence collection, the prescribed change was from the purpose to a purpose. In explaining its rationale, President Bush's administration stated that such a change would, quote, eliminate the current need continually to evaluate the relative weight of criminal and intelligence purposes, and would facilitate information sharing between law enforcement and foreign intelligence authorities, which is critical to the success of anti-terrorism efforts. Associate Deputy Attorney General David Criss testified at a September 24, 2001 hearing on the legislation that the animating purpose of the change was to bring the two sides together, allow for a single unified, cohesive response, and avoid splintering and fragmentation. Even then, some civil libertarians expressed concern. Critics of the legislation thought that simply requiring that foreign intelligence be a purpose of the collection was too big a blank check for the government to make use of FISA. As a compromise, the proposed law was changed from the purpose to a significant purpose. Buried in this change was, of course, a legal determination and also a cultural critique. Congress was calling for greater coordination and less concern about protective legal standards. So as a legal matter, that is where matters fell after 9/11. The FISA Court of Review, as an appeals court for the FISA Court itself, summarized the new standard. It said that the FISA Court should not deny an application if ordinary crimes were inextricably intertwined with foreign intelligence crimes. For example, a terrorist who commits bank robberies to finance terrorist activity could be targeted under FISA's less stringent standards, so long as foreign intelligence was a realistic option. Using the relaxed FISA procedures was acceptable. On the other hand, the review court said the FISA process cannot be used as a device to investigate wholly unrelated ordinary crimes. As a result, to meet the new significant purpose test, the government need only, quote, articulate a broader objective than criminal prosecution when applying to the FISA court for authority to conduct surveillance. Such broader objectives could include stopping an ongoing conspiracy. What all of this shows us, I think, is the cyclical nature of legislative and judicial branch regulation of national security activities over the course of U.S. history. Periods marked by little oversight and regulation, during which the president and executive branch enjoy relatively free rein in conducting surveillance and searches, are often followed by periods of backlash, public critique, and the imposition of new controls. The broadening of executive prerogative, in turn, often follows these periods, frequently grounded in some national security crisis. And so the pendulum swings back and forth over and over again. The CIA, the FBI, and later the NSA undertook extensive surveillance of Americans during the 1940s, 50s, and 60s, targeting everyone from KKK leaders to members of the Communist Party, to journalists and members of Congress, to Martin Luther King Jr. These activities were largely unregulated, and so the response by the legislative and judicial branches was to impose controls. Congress passed Title III, mandating judicial pre-approval of electronic surveillance. Then the Supreme Court decided the Keith case in 1972, interpreting Title III to extend to domestic security investigations. And then Congress passed FISA in 1978, bringing surveillance activities aimed at foreign intelligence collection under judicial review as well. A comparable cycle occurred after 9/11. The Bush administration took the position that the Patriot Act of October 2001 authorized its frequent use of the NSA to conduct warrantless surveillance. Then came public backlash, and later, somewhat greater restrictions. For now, we can end with a better understanding of why so many voices in the intelligence community were convinced that the government needed to share intelligence information more widely than it had before the 9/11 attacks. We cannot prove a counterfactual premise that had the FBI possessed the CIA's information, or had Colleen Rowley been authorized to work with the prosecutors to secure a warrant to search Moussawi's computer, the terror attacks would have been averted. But that is our suspicion. And so, as in Berlin a generation earlier, the wall had to come down.